I'm just saying. Yeah, that's all. No. All right, Ms. Rivers, are you ready? Okay, we're going on the record in 24 PI 008168. It's State versus Tyreek Robinson Baker. Good morning, Mr. Robinson Baker. I'm Judge McBurney. I don't think we've met before, but your case has been assigned to me just for bond purposes. The state may at some point indict you for what you were arrested for, and that'll be randomly assigned to some judge. It might come to me. Chances are it will go to a different judge. But as long as there is a question about bond in your case, then Mr. Tevis or Mr. Wolf, one of the lawyers working on your case, will bring that to me. So that's all we're working through today. Mr. Tevis, you are here on behalf of Mr. Wolf?
Yes, Judge.
Great, and we have Ms. Clark for the state. Mr. Tevis, I am ready to hear from you as to why Mr. Robinson Baker is a good candidate for bond and what that bond should look like.
Judge, you of all people are one of the are very well versed in the applicable case law that's going to be considered when establishing bond. But I would like to just go through 3 or 4 cases that have some pretty, I think, powerful language that is often forgotten in this building that I want to argue against the backdrop of that. So first of all, everybody's famous case in Georgia, Ayala, right? The purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of that person in court for trial. The most fundamental premise of our criminal justice system is that a person ought not to be punished for a criminal offense until and unless the state demonstrates guilt beyond a reasonable doubt. That is Vanderford versus Brand. In some limited circumstances, pretrial detention is permissible as a regulation serving a legitimate and sufficiently compelling government interest. And to that end, pretrial detention may be a permissible regulation rather than an impermissible punishment if it is rationally connected to a non-punitive purpose and is not excessive in relation to that purpose. And that is Carr v. State 303 Georgia 853 from 2018, which quotes United States versus Salerno. In our society, liberty is the norm, and detention prior to trial or without a trial is a carefully limited exception. And what that means is that the default position should be that a person is released prior to trial. That is the default position. We don't say this person has serious charges, they should stay in jail, because they haven't proven, the state has not proven those charges beyond a reasonable doubt. The defendant is always going to be at a disadvantage. We do not have the benefit of discovery. We don't have any of the information on which the accuser gave to the police that caused the warrant to be issued in this case. And so with that in mind, I suspect, as in the many hundreds, if not thousands of bond hearings I've done, the state will rely heavily on the facts because the bond factors are favorable to Mr. Baker. He's 27 years old. He was born and raised in Marietta, Georgia. He went to Sprayberry High School. He graduated from high school in 2015. He worked throughout high school. He worked at a Wendy's. He also did deliveries for his uncle's trucking company. He has continued to work doing that part-time upon graduation, and also worked for FedEx making deliveries and working in their warehouse. He did that until he was involved in an auto accident as a passenger in a FedEx truck and was injured. He stopped working there. He then worked for AQC Traffic Control, which does construction projects where they, divert traffic and make sure that that's a safe environment. He has a history of employment here in Georgia. He has strong ties here in Georgia. His parents are here in the back, if you could stand up. And his mother, I think, was in the hallway. She may not have had her ID because of the media case, they're not letting us in.
Right.
But his family is here. They're in constant contact with our office. If he's released on bond, Mr. Baker would reside with them in East Point. I don't have a GCIC, but I am aware that he has one prior incident involving, I believe, marijuana, and there was a firearm in the vehicle, not his, but I believe that he either has a charge or was sentenced in that case. I'm not aware of anything else that would show that he's a danger to the community or risk of committing further felonies. On paper and in reality, he is very tied to the community. There's no risk of fleeing here. There's nothing that would indicate that there's going to be intimidation of witnesses or anything like that. In fact, a preliminary hearing was conducted. We have a transcript of the audio of that I've reviewed, and it was the opposite. The alleged victim in this case called him repeatedly, I think 12 or 13 times, and demanded that he provide money to her, and threats were made to him, but nothing in the other direction came out at the preliminary hearing. I can go into the facts of that. I'd rather not, because true to my word, I want to say that bond hearings are not about the facts of the case, but if the state is going to get into that, then I will come up and would like to rebut whatever those arguments are. But given his presumption of innocence, he is factually innocent. He is legally innocent. The Constitution of the United States and Georgia both require that we stand here right now, assuming he has not done the thing that is on the calendar. So looking strictly at those bond factors, he does qualify. He should be given a bond. And we would ask that that bond not exceed $50,000, even though that bond is going to require his community, his family, his friends, his extended family to pool their money together to be able to even make a bond under those circumstances. But there should be nothing, it is not required to be exorbitantly high just to ensure that somebody returns to court. I mean, this is his community. So we would ask the court to take that into account when setting the bond.
But not a particular dollar amount?
I said no more than 50,000, Judge. I think, I believe that 25,000 would be appropriate. I know your background, having worked in federal court. I have clients with extremely serious, complex charges with life sentences at the end who are released without money that are allowed to come to court and turn themselves in. I wish we did that more at the state level, but I'm cognizant of the fact that the common practice is to set a high bond, which in all honesty is, enriching the bonding company, but I don't think that really it does any more to ensure that a client does or doesn't come to court.
Where would your client stay if he posted bond?
He would live with his parents in East Point. I can provide the address off the record.
Okay.
If we need to do
and
that.
That's where he was living before, or that would be a new address for him?
No, that's where his family lived then.
Okay.
Yeah.
The warrant for this was sworn out in June, and your client wasn't arrested for many months. Any insight into that gap?
I don't have information on that. It also came out at the prelim that the incident date was supposedly in March. And so I think there was one that was
May. It's May.
I'm sorry, there's a delayed outcry.
That could be, but
Yeah.
the incident date was May
23rd or something like that.
May 3rd. And then the warrant is in June, and then an arrest isn't until late. I'm just curious if you had any insight into the gap between June and November.
I believe that police were in touch with him, and I think that Mr. Wolf arranged for him to be turned in on that, but I don't have details as to why there was a gap in that. Obviously, it wasn't a situation where he's on the run or anything like that. I'm not sure if they were in discussions or talking to him, hey, we'd like you to come in and talk, and they were not effectuating the warrant because they were hoping that he would come in and speak with them.
Right.
But I don't have information that he was fleeing or anything like that.
Okay. All right.
Thank
you. Ms. Clark. Oh, Ms. Clark, before you go, you will come on, I have to tell you, good morning. I think Ms. Jackson, how are you doing?
Oh, I'm great. How are you, Your Honor?
I'm well. This was an add-on calendar that came out late yesterday, so I don't know if you had a chance to look up Mr. Robinson Baker's criminal history.
Yes, I do have it, Your Honor.
Great, if you'd share that, please.
Yes, sir. He has 4 cycles. The last arrest was August the 24th, 2021 in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a crime. He does appear to be on first offender probation in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a felony. That disposition date was February the 1st, 2023, and the term is for 5 years. He does have 1 prior misdemeanor conviction. It's in 2022 in Cobb County for a non-fingerprintable offense. Nothing in addition, Your Honor.
Thank you so much. Officer Evans, I wasn't going to be calling on you today, I didn't think, but do you know if there is a warrant in the system for Mr. Robinson Baker for his probation out of Cobb in light of this situation?
Good morning, Your Honor. Yes, Your Honor, there is an active
I can't hear you. It's odd. You're not muted.
Warrant at this time.
Can't hear you.
Your Honor? Can you hear me? Okay. Your Honor? Can you hear me, Your Honor?
Other people can hear you. That's peculiar. Some of my staff said they could hear you, but it's not coming into the courtroom. I don't know what that deal is.
He is on
But
active
if you just want to type it in the
probation.
chat, whether there's a warrant, I'll relay that. He is not yet. He does have a warrant. Okay, thank you. That's what I needed to know. Appreciate it. Ms. Clark.
Good morning, Your Honor.
Good morning.
So to answer, I just wanted to start to answer your question about why there was a space in time from when the warrant was sworn out and then when the defendant was actually arrested. From speaking with Detective Shields, he's indicated that he had, in speaking communication with the defendant, he was trying to give himself an opportunity to turn himself in. After a few months, the defendant did not turn himself in. So that is when he went ahead and issued the fugitive warrant to have him arrested.
Okay.
So that
Mr.
is
Tevis said something about Mr. Wolf getting Mr. Robinson Baker to turn himself in. Your understanding is contrary to that, that he was given an opportunity to do that, but that's not ultimately how it played out?
Yes, Your Honor. That's
Okay.
not, so in lieu of that, that is why that you have the delay in the arrest there.
Okay.
And Your Honor, counsel opposite refers to, he is correct. A person is innocent until proven guilty, but we're not here for that. We're here for bond. And to address that, we're looking at the Ayala factors. Your Honor, the state wants to bring the first reason we feel that the defendant risk of flight. It seems that based on counsel opposite's information, he seems to have strong ties to the community. However, a threat or danger to the people. Want to point out the fact that the defendant does have a past DUI conviction. Have a past DUI conviction, as well as showing the fact that bringing the court's attention to the fact that when he was out on bond in Cobb County State Court for the DUI arrest, he was subsequently arrested in Cobb County after that on 8/24/2021 for a drug possession charge, felony charge, Cobb County Sheriff's Department. That is on cycle 2. That indicates, Your Honor, that the defendant fails to comply with court orders because he was on bond at the time. So I wanted to highlight that as well. Risk of committing felonies pending trial. The defendant currently, based on my review of the GCIC, is currently on probation with Cobb County for a marijuana distribution charge as well as a gun charge. He had a total of 7 years. The gun charge, of course, was 5 consecutive, so he is still on probation for that. Based on the jail, my review of jail booking and Odyssey, it indicates that Cobb actually has a hold that they placed that says no bond on that. So I'm pretty sure that that is likely because of this arrest. There is a strong risk of intimidating witnesses, Your Honor. In this particular case, the victim knows who the defendant is. There's a young lady, Kim Yee, who actually was a friend of the victims at one point. She actually ended up coming over to the place where the incident location, where the assault happened. So these people know each other. And there is an intent to intimidate the witnesses. Ms. Head, the victim in this case, says she fears for her life and that she does not wish for him to have bond. She is actually has provided a statement to our victim witness advocate that she'll read for us. But this is a serious capital felony crime, despite counsel opposite's suggestion. It is the nature of the crime does warrant a no bond status. And that's what the state is asking for. We believe it's appropriate in this case because the defendant is currently on probation. He has shown that he does not comply with court rules as he has violated bond orders when he was actually on probation. And as I said, he's on probation for the drug marijuana with intent to distribute and the firearm charge out of Cobb County. I think that he has a high risk of intimidating witnesses because of the fact that there is a friendship between the female that was assaulted. I think the roommate or something was also, he knows the defendant. So there are a lot of people that the defendant will have access to. And so for those reasons, I think that bond should be denied.
All right, thank you, Ms. Clark. So, Mr. Tevis, you had asked to have rebuttal time. You certainly can have that. I'd ask you to include in there what more you can add, because I believe it was your client's father was sort of raising his hand on this issue of the delayed turn-in. That's getting more mysterious to me. And it's not dispositive here. Sure. I think the Cobb situation is for a temporary ruling that I'm going to make, but if you could clear up as best you're able, knowing that you're parachuting in as well, sure, what your understanding is with, hey, you should turn yourself in, I'm not turning myself in, however that played out. Sure. My understanding is that the police were talking with Mr. Baker Robinson. They wanted him to come in, as I said before, make statements, talk to them. He was waiting to hire counsel. He also had some private family medical issue he was trying not to go in about. I've checked our records. Mr. Wolf was hired at the beginning of November. I know that they were talking and meeting with him in October. And so the last couple of months were, you know, Mr. Wolf was talking to police about arranging a turn-in at the jail, which they did, and they surrendered him. So ultimately, there may well have been before, I'm gonna call it your firms, but before the collective legal involvement of you and Mr. Wolf and others, who knows, there may have been some back and forth, and, and the police may have perceived that your client was reluctant. Right. It's not like he's under an obligation, but he was reluctant. But in the end, the way that your client went into custody is that a lawyer escorted him to the county jail or wherever. Correct. He was surrendered to Fulton County Jail. Got it. And the state's perspective is, gosh, that took a whole lot longer than it should have if this was someone who was coming in to say, hey, let's clear this up. Sure. And I understand it, and that's a reasonable perspective. Anything else you wanted to add? Sure. I could guess that probably part of the delay could have also been, if we're guessing, that police were just kind of lazy in this case. I mean, you can call someone and say they have to turn themselves in, but in reading the preliminary transcript
Interestingly, that the state brought up, hey, well, let me back up on that. The buzzwords that I'm hearing from the state that I usually hear are, I think he's a danger to the community. We believe, the state always believes that, they always think that, and they always oppose bond. I mean, the credibility in the building, there aren't even cases where they consent to bond at first appearance, not even just serious violent felonies. And the state is correct that the court can and should consider the severity of the offense when setting bond conditions and the bond amount. But to say that the severity of the offense disqualifies from some bond is in direct contravention of Supreme Court precedent, Georgia statute, US Constitution. That's just not the case. Ayala is a murder case. That's where we get all these good languages and everybody quotes it when in fact it's actually codified in the statute. So the charge itself is not dispositive. With respect to he knows people, so we think he's a danger, both of those witnesses testified for the defense at the preliminary hearing, contrary to what the victim alleged. They were both present. The victim, they said, called us and said, hey, are we drinking tonight? Can I come over? She showed up with an open bottle. She was pouring out, taking multiple shots, all of those things. That is not evidence that he is a danger in any way, shape, or form. Both of those witnesses testified that they were there, they didn't hear anything, they saw them together, she was cuddling in bed with him, all these things. So at the outset, even though the offense looks serious, there are various flavors of what this charge could be. Georgia has no degrees. Something that's ultra serious, violent, stranger on stranger is the same thing as people were drinking and they wake up and don't remember what happened. But that is not what was happening here. Both of those people that the state cited testified, were called by the defense under oath and directly contradicted what the alleged victim in this case said. So as far as the severity of the offense, the charge is very serious. As far as the strength of the case, we would contend it is not. And so far, he's still continuing to be incarcerated on a case that he's presumed innocent, in which we don't believe is a factually strong case for the state. So because of all of those things, we would ask that, again, the bond not exceed $50,000. We don't care if he's confined to an ankle monitor or even home confinement except for work, but he should not continue to be held in custody with no bond, given the light of he meets all the statutory factors. And again, the strength of the state's case at a fully drawn out preliminary hearing with an officer and witnesses was more favorable to the defendant.
Okay. Well, it wasn't, I guess, so favorable to the defendant. Judge Brooks still found probable cause to bind it over.
Judge, that's such a low standard.
But it's not that she said, I'm dismissing this charge.
Right.
Okay. All right. Is it Baker Robinson or Robinson Baker? I apologize if I was reading off the calendar I had. How do you say your last name?
Robinson Baker.
I got it right. Good. Mr. Robinson Baker, I'm going to leave you in a no bond status for just one reason, and it's a reason that can be addressed. You're on first offender probation out of Cobb. That's a delicate situation for you. This has come up while you're on first offender probation. Cobb has issued a warrant saying we need to see Mr. Robinson Baker to talk about what was going on in May of this year while he was on first offender probation for the marijuana and gun case. And I want to get you there so that can be addressed. Should that be addressed, and the only thing left holding you in custody is this no bond situation, we'll reconvene and we'll have this conversation again. Your lawyers will have a little bit more time. They might be able to produce a couple of these witnesses that they were talking about. And your situation, I've heard about the stability of your work and your household situation and all that. I won't need to hear that again. But what has come up most prominently is that you actually have a warrant, and I need to make sure you get to Cobb. And so I'll do that. You and a lawyer in Cobb will figure out what the consequences are, if any, for having been arrested in this situation on your first offender probation. And once that's been resolved, you come back here and we'll revisit this question of bond, and there won't be that cloud of, wait a minute, I could give you a $1 bond right now and you don't get out. You would go straight to Cobb. And I want to have that dealt with, and then that'll be off the ledger and we'll figure out what kind of bond, if any, makes sense in your case. Any questions about that?
No, sir.
Okay. Mr. Tevis, anything else on behalf of Mr. Robinson Baker?
Judge, just questioning the mechanics of how we're effectuating getting to Cobb. This would just be some kind of transport order because he'll have to be released from this hold to get to Cobb.
Right. We'll work with Cobb on that so that then there's a hold put back in place. But we've done this before where someone goes to a neighboring jurisdiction. If it was Pennsylvania, I wouldn't be comfortable that we necessarily get them back, but it's an adjacent county. And so I'll work on the logistics of getting Mr. Robinson Baker there. And then I know you or Mr. Wolf or someone will let us know, hey, that's been resolved and he's back in Fulton. We need to address this again. Okay. Very well. Ms. Clark, anything else?
No, Your Honor.
All right. Thank you.